only was okay. Have I told him about it? I don't know. I just texted you. She felt better, but I'll let you know. And Libby may have gotten with you, DT. I'm not sure, but she will not be here tonight. She's having some health issues.
Oh, really?
I
Sorry.
think
I saw an email from her, but it didn't say anything about that. Just had some attack. No, it wasn't from her. I'm sorry. It was from Amy that she said something
on her behalf, and she thought she would be here, but I think she's had some just in the last little bit. Yeah, just this afternoon she's had some, nothing major, but some issues that's kept her from being able to be here.
Mm-hmm.
Have we got the rest of the members here, at least, so we have a quorum?
Yes.
We do.
We have a call.
We are now live, guys.
Is Ron here?
Yeah, I'm here, DT.
I don't see you, but I take your word for it.
Your lucky day. You don't get to see me.
Lucky day.
You don't have to look at me. But you should see me. I'm on video. Josh saw me.
All right. Well, I suppose we can call the meeting to order. It's time to do that. The agenda is up. Do I have any additions or subtractions or contributions to it? If not, do I hear
One thing I'd like to do, DT, is just recognize, based on what Melanie just said, that we do have a quorum here. We got 3 members. Ms. Short, Libby's not going to be able to be present, but we can still proceed with 3, which is a quorum of the members. And I assume the other 2 are here.
Okay. The meeting, then we call it to order. And do I have an approval of the agenda?
Make that motion.
Motion, a second.
I'll second.
All in favor? Aye.
Aye.
Motion carries by everyone. The minutes, has anyone read the minutes of last month? I looked them over. I can't say I read them.
You just need a motion to approve those.
I know. Having discussed it, do I have a motion to approve the minutes for last month?
Motion.
Do I have a second?
I'll second.
Motion's made and seconded. All in favor, say aye.
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 Motion carries by unanimous. Okay, Ron, it looks like you're up for a report on the city ethics ordinance.
Yeah, last month, Libby had asked that I obtain a copy of the ethics code, which was apparently just passed by the city council. So I obtained that, and I sent, everyone should have got that in an email as an attachment. It was quite lengthy and has a lot of information in it. I discussed it with Libby just briefly to make sure what she was wanting, but there wasn't anything specifically in the code that she was asking that I look to. But I did talk with Billy Ray, and he'd indicated at the city council there was seemed to be a lot of time spent on emails and social media. So we'll look at that in just a minute. But my first question that I thought had to be answered obviously was, does this code of ethics even apply to this board? My answer, based upon the research and the review of the statutes, is that I believe it does. If you look, the ordinance has specific definitions in it, and one is the city agency, which is boards and commissions that are either individually or jointly created by the city. Of course, we operate under the Little TV Act, and this board is created, so to speak, by the Little TV Act, but the way the electric plant board was organized is, I think it is a city agency. When you look at the statutes that talk about why this code of ethics was enacted by KRS 82.082 as well as KRS 65.003. You can go to a bunch of different definitions, but that initial KRS that directs cities to have a code of ethics talks about boards and employees of special purpose governmental entities. And as you look at other definitions, I think we do fall under those definitions from the other statutes. I even found an old Attorney General opinion that certainly said a city utility board operating under the Little TV Act is an agency of the city. So I think that's why I think we are still covered by that as a city agency under those definitions. One question you would have then, how are we as board members? When you look at definition Q as an officer, I think that's what you as board members would be considered, because section 9 of that definition is referring to a member of the governing body of any city agency, of which the electric plant board is that agency, who've been appointed to that governing body of that agency, which all of you have been. So that's why I think if push came to shove, certainly I might take the other position if I had to argue to protect any of you guys from any discipline of this, but I believe you ought to operate as though we are covered by this. There are numerous sections of that, so I'm not sure what each of you may want to talk about in regards to the standard of conducts and other sections of the code, but I was going to just pick at some of those. Some of them are kind of self-explanatory when it comes to conflicts of interest and things like that. But there would be exceptions at this point for. I don't think anybody on this board has a conflict of interest with contracts that are into with the city, and it doesn't apply. It wouldn't apply anyway if there is. You'll notice there's exceptions to that. One, if any type of contract is awarded to the public after notice and type of competitive bidding, but I'm certainly not aware of any information that would say any of you could potentially have a conflict, certainly at this time. And if you had a contract before you entered into before you were appointed officer, then that doesn't apply either. And then section 3 provides some other specific exceptions. And a lot of those things are that if you think you have a potential conflict, you do need to disclose that of the record. And even in the code, the code of ethics has this board, and you can get advisory opinions from them also if you need to, and that's provided for back in the back section. If there are conflicts, I think section 8 takes care of that, where, if you're voting on something, you pretty much don't need to vote on that. Announce why you're not voting. That would be the potential conflict. And then just do not take a vote on that particular topic. Does anybody have any specific things that you want me to talk about? Because some of these others, like receipt of gifts, don't take gifts in exchange for what may be the influence of your vote on a particular issue. Y'all's votes are a little bit different compared to some other potential boards that could affect people, but obviously your votes are very important for the major issues of providing electricity. Section 10 about the use of property and equipment, I don't believe either anybody on this board has really access to that. You're not provided vehicles or anything that's going to give you some personal use. The representation, everybody has an opinion about various things. You're not supposed to represent somebody in connection with some type of proceeding before the board. You obviously could represent yourself for your own interest if there is a matter of importance to you before the city, but otherwise you're not to represent a group or any other type of a person or business before the city except for your own interest. I was looking more at the restrictions regarding emails and social media. And I think the things that you want to look at, that's section number 23 of page 12 of this business. And also I looked at the meeting attendance, there was potentially some question there. And when you look at that, that's talking, I don't think that applies to this board because it says all elected city officials and member of city boards. You are not elected, you are appointed and approved by the council. So I don't think you fall under that provision about not missing more than 1/3 of the meetings in the 12-month period. For social media, which is what I think Billy Ray indicated, took a lot of time at the city council meeting. It does, and you'll see in these throughout this thing that they seem to interchange officials and officers. Social media talks about city officials, but there's no definition of an official. There's just a definition of an officer. I don't know why they, in the middle of this thing, they switched from calling people city officers versus city officials, but you'll see that did switch. And the thing I think that they're trying to tell you in Section A of city officials about you can maintain your presence on social media, and then it defines what social media is, which is Facebook and those types of outlets. But you should not mention your status as a city official. It's not that you can't mention it as a city official. There's no prohibition about that. But it does, I think, try to make you aware that if you got a Facebook page and you mention that you're a member of the board, then you're potentially putting, what's on that site subject to some open records request. My suggestion is if you have a social media account and you do have yourself identified as a board member, you might set up a separate social media account for that board member, and then on your personal account out beside that, give that site, so that they wanted to contact you in that capacity, they could contact you more on that official social media site as opposed to your personal site. So Section A, I think, would apply to you all, but I think it's just, as I said, making you aware of the potential for some open records request. Section B is not going to apply to you all. That's elected city officials. You are not elected. Section C, just as I think that does apply, but it just conduct yourselves professionally and as a representative of the city. I think that goes without saying. Section D is, again, elected officials. E, I think, is also referring to D, which is elected officials that are supposed to keep everything in place. F does have city officials. Again, it doesn't say city officers, but it says city officials. They don't want you to conduct the city business. And the city says the city of Glasgow, but you're an agency of that city, through your social media sites. It's asking that if someone wants to conduct some sort of business with you regarding the electric plant board, you need to do that not through that site. I think that site's really going to be mainly as a contact to get a hold of you, and then you discuss anything you want to discuss through email or phone conversations. There shouldn't be much back and forth on that social media site. G is, again, elected officials. I do not think that applies to you. When you get down the next section for any type of social media or the internet is the emails, and it's telling you that city officials shall maintain an official email. It doesn't say you got to have a social media account, but an email address. And it doesn't say you got to have a separate email address. So I think you as a board do have an email address. Melanie, I'm not sure from maybe Melanie and Josh can answer this question, whether is the public aware of that email address, how we exchange information back and forth?
Yes, they are posted on the website, and the community can also email the EPB board mailing list is also posted on the website.
Okay, so if you do have if you have your own email address, I mean, it says an official email address. If you want your official email address for being a city official or officer, I think you need to be sure that just shows as the electric plant board email address for the board. That is supposed to be provided. It says provided to the city clerk. That's not been done. We need to make sure that has been done, but I would think that has been done. And this email address, if you're going to have an official address, you need to have that separate from your personal email account. I know all of you, I think, have email accounts, but that shouldn't be the one that you consider as your official account. So if you only got one email account, you want to be sure that you've got listed for your official one as the EPB board. There are questions also about these financial disclosures. If I'm not, since I've been at least the attorney, I've heard some discussion about you as members filling out a document regarding any potential financial disclosures. Do you all do that at this point?
Do it, city council, yes.
So Marlon already does it as a city council. So the question is going to be, do you all have to do it as part of this code of ethics? Now, the board of ethics is supposed to, within 90 days after it's formed and by February the 1st of each year, create the list of who all is supposed to provide that financial information. If you're on that list, you're supposed to get notice about it. Of course, I don't know that the board of ethics has gotten organized yet. I don't know who's on the board of ethics. Marlon, is there a board of ethics? Have y'all decided who's on that board at this point?
I think they got the full board right now, yes.
Okay. But you're supposed to be given notice, and then the contents of the financial interest statement it sets out very clearly what you provide. The good thing about it, of course, you don't have to put any kind of specific dollar amounts, individual clients or customers or business lists regarding your sources of income. So I'm going to try to get a copy of what this financial interest statement is, which is what they're supposed to provide to you, so that we can look at that and see what information you may or may not need to do. There was one other section I thought that was important when you talk about the contents of the financial interest statement. Oh, that's not the one I was thinking of. They will have the good thing about all of this is that they do have this board, and there are a lot of due process requirements in there where they can't just fine you. They got to give you notice of a complaint. You've got the right to respond to that complaint. The board has the right also to look at some complaints and just go ahead and summarily dismiss those and not take any. They have to investigate them, but they don't have to take any further action on them. But you've got the right to respond to all of those types of complaints that may be filed against you. If anybody, certainly if you receive any complaint that is filed with the Board of Ethics, let me know as soon as possible so that I can advise you on how we need to respond and your time requirements. All those are set out in there, but you will be given a hearing if necessary to be able to present your response to that complaint, as well as call witnesses, and all of that would be under sworn testimony. There's one other section I wanted to be sure and tell you, because some of it, one section actually didn't even apply at all, because it did not take effect until this particular ethics code was approved, and all of you have been on this board prior to its approval. So some sections will not even apply to you. Do you have any, as I said, if you look over this thing, and it probably would be better, and I don't mind printing it out for you and sending it all to everybody, so you can look at it as opposed to trying to look at it on your phone or the computer. So you can make notes, and certainly you could free to call me about any specific sections that you have. If you've looked at it already and you have a specific question, I'll be happy to listen to it and try to answer you now. But there's just a lot. I mean, there's a lot to it, but it's not. There's not anything they can do with this code of ethics. They can't change what the little TV Act provides, which is talking about the reasons for any dismissal of a member of the board. You got to have negligence, misconduct, those types of things. So the code of ethics cannot do away with those requirements, but they can place some, just ethical aspects of the position on you. That's about all I have, unless somebody's got a specific section that they have a concern about, or if you look at it later and have a concern, just call me and I'll try to explain it to you.
Okay, Ron, thanks a lot. Our next up is the rates discussion, which we have been working on. The staff, Melanie and Josh, have confronted TVA in the process of trying to get the kind of rates we want, and we have came to a agreement as to what we want and what they will allow, and I think it's pretty well defined. And if we want to do anything else, it will considerably delay what we're doing tonight. If we go ahead with this, we can get it done now and be on it. Josh, would you like to give a rundown over your cheat sheet?
Well, I can. You have this on a slide. So yeah, Melanie made a really nice slide here. So basically what we're looking at doing is the residential customer charge will load from $31.97 to $21.54, or $25.54 for the residential customers, normal residential customers. All time of use and coincident charges for those customers will go away. It will be a flat rate that will be basically around 10.3 cents on average. It will be seasonal, so you will have a winter, a summer, and a transition. So you will still have those changes, but the CPD portion of that is gone, as well as the time of use component on and off peak. Small commercial, which is, it's kind of a tricky thing to say small commercial, because a small commercial under this can be anything that basically it's under the same name, the person's same name, and has a secondary meter. So for example, you could have a garage next to your house and you could have a second meter because you're not powering it off the main structure. It becomes a small commercial under the rules and regulations. Customer charge on that lowers from $56 on the variable rate to $42. All time of use and coincident charges also go away. The same thing as the same thing basically that the residential rate does, except they're a little higher. They're to around 10.6 cents a kilowatt hour. Medium and large commercials stay 100% with the variable rate, known the infotricity rate. Those commercial, basically those customers are already revenue neutral. They're paying for what they use, and we're getting their money away, our money back out of them. And because of that, what TVA is allowing us to do is take the whole of the 3.1% partnership credit that we got from the long-term agreement, and we're applying it to residential and GSA1 residential and small commercial in order to knock their prices down. So I said that really fast. If anybody's got any questions.
I think you guys did a good job in discussing it with them and presenting it what we wanted, and it just about exactly does that. It doesn't mess with the industrial rates. It lowers the tap-on fees, which is essential. From our discussions, it seems that they are willing to drop this tap-on fee over a period of time to a lower number, which I'd like to see about $15. But right now, $25 is an improvement, and it'll be a while, but they like gradualism, and so we will do it slowly. The base rate basically costs the people who are using lower amounts of power more because they don't use as much power. Therefore, their power costs more. And I'd like to see that further pushed down when it's optional. But this is as close as I think we need to be to where we were and where we should be. Unless anybody has any real serious objections, I'm hoping we can approve it.
So Melanie has another slide here that she's going to be better go off. I'm just the number geek. She's the wizard behind the money. So she's
the details.
So she will. She can probably explain this one to you a little better. Give you a little example of what's changing per tariff.
Yeah, this is just, as it says up there, the consolidated total revenue dollars. So this is taking the total revenue that we're getting from each class and showing you what that is currently, what it would be on this new proposed rate, and what the change is. So you see there, like Josh said, the residential and small commercials are going to see savings of about 4%, and the other classes will stay the same. And then the next slide, it just shows the same information a different way. It's on the individual bill. So this shows average residential customer bill now, and that is whether they're on the variable or the flat. This is just an average of both of those. And then what it is proposed to go to. Of course, these are not, obviously every customer is not average. This is for the average customer around 900 to 1,000 kilowatt hours. If you use less than that, you're going to see significant savings. If you use more than that, you're going to see a possible increase. But on average, you're going to see these reductions for the residential and the small commercial customers. And
So no real changes in the medium commercial or large commercial, right?
That's correct. There would be no changes. They would stay on the rate they're on now, which is the peak, the time of use rate, just like they have been. The only thing, when TVA decided to give us, or everyone that signed the long-term agreement, the partnership credit, the board, you all decided not to pass any of that through to the customers. So we've been keeping that money sort of as an emergency fund. What they are doing here is passing back not just the residential and small commercial portion, but the 3.1% in its entirety to the residential and small commercial customers. With that, we have to keep those medium and large commercials on the rate they are now. Once we take them off of that rate, those credits would have to be passed through to them.
Okay, guys.
I think for now, this is a pretty good compromise.
Yeah, I do too.
I appreciate you guys being helpful in negotiating this.
And one thing, we are getting the partnership credits. We're right now also getting the pandemic credits. So those are not included here. Those we would still be able to keep for possible, or for any future use we may have, including if we want to give more in the future to community relief. And of course, that is not included in here because we have already set that money aside. So that's not being shown in here.
Okay, guys. Any further discussion from anybody? If not, do I hear a motion that we proceed with adopting this rate system that they've proposed?
I'll make that motion.
Have a second?
I'll second the motion.
Have a motion and a second. No further discussion. All in favor? I guess we should have a roll call vote here. Glenn?
Yes.
Marlon?
Yes.
DT votes yes. Motion carries. Okay.
So one thing about this, guys, we just want you to know, like, this isn't going to be snap our fingers and this happened. This will have to go back before TVA for approval. They've already given us somewhat approval, but it will have to go back for official approval. And then there will have to be other things, billing system changes and whatnot before this happens. So it could be a couple of months out.
Yeah.
Yes,
But
we
we'll
know.
be by next month, should be able to give you a definite effective date.
Yes.
Yeah, I understand.
Yeah, we get it as when it happens. It'll be great. Okay. Next item up is
This is just informational. We've talked about this the last couple of months. But we do have the write-up for the advertisement. It also includes some information just on Glasgow as well as a full job description. So we'll be putting that information out either the end of this week or first of next week, just so you all will know once we start getting those applications or any type of questions in that we can't field, we'll make sure that we get it to you all.
very good. I guess we're ready for the superintendent's report on the issue of discussion of the search for a superintendent. Melanie, you were looking into that. What are we doing?
Yeah, that's what I was just saying, that we're going to be putting those advertisements out the end of this week, hopefully.
Okay. All right. The next thing is the superintendent's reports. The floor is yours.
Actually, I've got the next thing is the audit proposal. So if it's okay, we'll go ahead with that one.
Go ahead.
Okay.
Go ahead.
That's all right. We did send letters out to 5 local firms. We had 2 responses that declined a proposal, 2 we did not hear from. So we actually received 1 proposal, and that was from Carr, Riggs and Ingram, the firm that has been doing the audit for the last several years and do a great job. That has already been sent to the City Council's Finance Committee. They approved it last week. City Council approved it last night. So we're just asking for you all to go ahead and get this approved so they can start their preliminary test. And this just shows you their fees that they're proposed for the next 3 years. And they plan to start next month and then would issue the audit in October.
We need a motion to accept their proposal.
Yes.
Motion.
Do I hear a motion?
Motion.
Motion's made. Have a second?
I'll second.
Have a second? No further discussion? All in favor? Aye.
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 Motion carries.
Okay, now we're to the reports, and they keep shrinking, and we'll make changes here as you all request them, or things that we see that you all need to know that you're not already getting in the board packet. We do give you sub-counts for the broadband services. We haven't been giving you much on the electric, which is why this shows up here. This first graphic just splits out the variable rate and the flat rate customers between residential and small commercial. And of course, once we make this rate change, that will go away, so there won't be any difference in those 2. The bottom one shows the monthly load factor, and you can see March looks very good. The weather this month was pretty normal, nothing out of the ordinary, so pretty high load factor for March. And then the last thing I noticed on the agenda, I had April's FCA. It's actually May's FCA is actually decreasing by about 0.3 cents this month. If you'll remember, last month it went up, and this month it's going down slightly. And I don't have any other items unless there's some questions that you all have.
Not from me. next item on the agenda is discussing the format. And I would like to propose we make a change. And that change being that any board member who wants to meet in the boardroom can, but anyone else wants to meet over the Zoom, and we keep the Zoom going to satisfy the open meetings requirements. We keep the Zoom meeting going, but we can meet in the boardroom. I would like to propose that we do that. Any discussion? Anybody care?
Yes.
Judge, DT, I was going to tell you that, you know, I've checked into that too about some of you being present, some of you being by Zoom. I don't think there's any issues with that. It's just when the notice goes out about the meeting, we would need to be sure we, you know, include both places, but the public obviously, you know, trying to maintain social distancing still for our boardroom. You couldn't get anybody in there, but pretty much the board and Melanie and the ones that need to be there. So we want to be sure we still have that Zoom. Josh will still have to advertise, or Amy advertise the Zoom information. And if a board member wants to participate, they would still be able to participate by that method.
Well, that satisfies the fact that we would have to have meetings where you'd have the public there. This gives them access without having a whole crowd. So it works out very well that way. Do I hear a motion that we accept this procedure?
Motion.
Have a motion? Have a second?
Second.
Have a second? All in favor? Signify by.
One thing, DT, we want to make sure, I guess we need to, maybe as each meeting takes place, maybe the members can let Josh and Melanie know, you know, who plans on being there at the boardroom, just to be sure we've got the appropriate space and someone's not necessarily forced to go back to Zoom. So there's plenty of space.
Okay.
I had one other topic I meant to bring up. I just wanted to notify you of this. There's been a lot of statutory changes or proposed bills regarding this, mainly open records and open meetings, mainly open records. Currently, we don't have any final answers yet, but currently under that House Bill 150, you had 10 days to respond to those requests. There was a House Bill 320 that was going to go into place. The governor vetoed it. And then the legislature overrode that veto. And then now there's litigation in the Franklin Circuit Court there in Frankfurt, where I think there's a temporary injunction about the enforcement of that. And the two of the most significant issues, really, I think the most significant issue is when it talks about open meetings. It used to be the statute said a person could ask for those open records. Now there's a definition, and it requires a citizen of the Commonwealth, and then gives definitions of what a citizen of the Commonwealth would be. So I think that's something the governor did not like and got them to where they are today. The other change, where it's currently 10 days, the old rule before COVID was 3 days to provide that information. It looks like it's going to go to 5 days. I don't think, to my knowledge, we've ever had a problem in providing it within 3 days, but there may be occasions where that's a problem. But all of that's still kind of way up in the air. I spoke with a lady who was very informative, Amy Bensonhaver, who was quite knowledgeable about what the current status of all that stuff was. It may be something, once it finally lands where it's going to land, she may be a very good source of information, and indicated she'd be willing to come down and talk to the board members, as well as any other members of the public, or possibly maybe city council members that want to join in with all these changes in the open records. But I just wanted to let you know that'll be things we'll have to change, because one thing, you know, we've got on our site, and this is not something necessarily the board has to do, but we've got on our site how you can request emails. I think the Attorney General was trying to come up with a standardized form that we can submit once that's out. But you can also now, you have to accept email requests where you didn't have to before. I think we've always accepted it. I think Billy Ray's always accepted email requests. But we may have to modify our current notice some. Josh, I'm not sure who puts together that notice that's on the site, but we may need to take a look at that once this litigation finally ends in Frankfurt, to make some slight modifications about how you can make those requests and provide that standardized form. So that's just something that's still in the works, but I wanted to be sure the board was aware they're trying to, they were arguing about how long the governor can issue his emergency orders. And they wanted it to be 30 days before they expire. And then there's legislation, the joint resolution Joint Resolution 77 that was going to let it all take effect 90 days. But right now it's so up in the air, you don't know when any of it's going to take place. But except for sure something's going to happen by I think the end of June. I'll keep looking at that stuff and report back as necessary, but I think we will have some changes in responding to open records requests.
Okay.
That's all. I just wanted to give you that. I meant to give that to you earlier. So.
Okay, well, I think we have a motion to change the meeting format. And we have a second, and I think the discussions are about over. Do I hear all in favor indicate by saying aye?
Aye.
Aye. So motion passes. And with that, I guess there's nothing else to do but adjourn. So
A motion to adjourn.
I have a motion to adjourn.
Second.
Yeah, motion.
All in favor? Aye.
Uh,
Thank you. We're all done.